Present developments in space law. Before we begin our presentation on space law, we feel the need to point out that most of the artwork you will see illustrated throughout this presentation has been generated through AI prompts. Additionally, my voice is generated by AI, even though I am not even a real human. Blake has just told me what to say to you all today. Pretty neat, right? The present day represents a significant era in the history of mankind's exploration beyond the boundaries of our planet. Born through the bitter rivalry between the United States and the Soviet Union, humanity's drive into the unknowns of space has continued to evolve far beyond its Cold War limits. Through remarkable advancements in space technologies and knowledge, the modern space race is no longer a race solely between two global hegemonies. Today, the space race has many global contenders, over 70 nations, all of which have established state-funded space agencies to facilitate exploration, research, and development of space resources. Of these nations with space operations, 16 claim to now have the requisite capabilities to physically launch humans into our orbit and beyond. To further complicate the mix, more and more private actors and non-governmental institutions continue to wade into the fray, creating programs for commercial purposes and other ventures into space. Space law defined. As more actors continue to enter the arena of space, the evolution of space-related endeavors has catalyzed many developments within space law, the collective international and domestic legal frameworks which underpin the parameters of mankind's activities within Earth's orbit and beyond. At a basic level, space law encompasses a collection of international and domestic laws and regulations that govern space-related activities on Earth and in outer space. International space law. During the Cold War, tensions between the United States and the Soviet Union precipitated the need for an international legal framework to encourage cooperation and peaceful operations into space. In response to this fervent rivalry, the United Nations General Assembly adopted the Outer Space Treaty, OST, in 1967, which stipulates that any exploration and use of outer space shall be carried out for the benefit and interest of all countries. Under the OST, the launch of any objects capable of carrying nuclear weapons or any other weapons of mass destruction into Earth's orbit or elsewhere in space is not permitted. Further, the OST forbids installing such weapons on the Moon or other celestial bodies and calls for such areas to be used exclusively for peaceful purposes. While the origins of space exploration were rooted in the intense rivalry between the United States and the Soviet Union, the modern era of space exploration is characterized by a significant degree of international cooperation. At the international level, space law is structured around two categories of legal instruments: binding, such as treaties and regulations, and non-binding agreements, often used to express interests or ideas in the search for consensus. Under the current frameworks of international space law, nations are generally responsible for all space operations that occur within their respective borders, whether governmental or non-governmental. These governments are also responsible for the authorization and supervision of non-governmental space operations. For example, the most significant development in international space law has been the Artemis Accords, a U.S.-led series of non-binding bilateral agreements between the U.S. government and its counterparts worldwide. The Artemis Accord seeks to guide civil space exploration and use in the 21st century. In addition to guiding the overarching mission of space exploration, the Artemis Accords also seeks to foster international cooperation, transparency, interoperability, emergency assistance, deconfliction, space object registration, scientific data sharing, and the protection of historical sites, artifacts, and resources in space. As of February 2024, 36 nations have become signatories of the Artemis Accords, a figure which is expected to grow further in the coming years. While agreements such as the OST and the Artemis Accords provide a legal framework for international space operations, such agreements leave many legal questions unanswered and unattended. To fill in these voids left in the wake of existing international agreements, the domestic level of space law provides additional legal mechanisms for those individuals or entities choosing to engage in space-related activities. U.S. domestic space law. At the domestic levels of space law in the United States, this framework is comprised through a complicated network of statutes, regulations, and policies which define our own space operations. The U.S. Senate recently passed S.447, the Orbits Act of 2023, which aims to reduce space debris in the Earth's atmosphere and promote safer space operations. If the bill passes through the House of Representatives and it's signed into law, it will, among other things, necessitate the establishment of a NASA program which would demonstrate space removal to foster space debris removal technology. In the House, the Commercial Space Act of 2023 recently passed through the Science, Space, and Technology Committee and awaits a vote on the floor. If the legislation were to become a law, the act would designate the Commerce Department's Office of Space Commerce as the foremost authority regarding private space missions and their supervision. Private actors in space. While the space race has traditionally been a race between competing nations, recent political and economic shifts have prompted the rise of private, commercial entities to search for opportunities in space. Driven by rapid technological advances and decreased operational costs, these private entities driven towards space are seeking to profit from a broad variety of space ventures. Traditionally, many private entities have received state funding to fulfill the initiatives of the supporting governments in space. Recently, however, more businesses and industries are launching space operations independently of their respective governments. As this trend continues to progress, it is estimated that non-governmental activities in space are set to take center stage in the space race in the coming years and decades. The rise of civilian space tourism. One area expected to boom is space tourism, where private companies, such as Jeff Bezos' Blue Origin Enterprises, LP, Blue Origin, take civilians on short endeavors into space. Since its founding in 2012, Blue Origin has launched 6 separate civilian crews from Earth and continues to increase its efforts to further space tourism. Similarly, Richard Branson's Virgin Galactic also conducts commercial space tourist flights for civilians. Having successfully launched civilian passengers into space, Blue Origin and Virgin Galactic both seek to increase the size of the space tourism market and outclass the other in doing so. While these civilian flights merely reach outer space and do not enter orbit, that may soon change as Blue Origin and other companies have announced plans to establish a commercial space station in the coming years. Space mining. Aside from launching civilians into space, recent trends demonstrate a desire to reach further into space and upon the Moon and other celestial bodies. In 2016, for example, Moon Express, a lunar mining company, was granted permission from the U.S. government to operate beyond the International Space Station and ultimately land on the Moon. While Moon Express ultimately failed to raise the requisite funds necessary to begin mining the celestial bodies of space, the goal of harnessing the unknown potential wealth of space remains a mission for many. Companies such as Astroforge, Trans-Astronautica Corporation, and Karman Plus continue developing the technologies necessary to mine asteroids and return their product back to Earth. Outside of the civilian and private sectors, recently, U.S. and Japanese space agencies have sent spacecraft to investigate asteroids for the purposes of learning more about the potential they may possess. In 2023, NASA successfully returned a capsule from the near-Earth asteroid Bennu containing a one-of-a-kind sample for examination. While space mining remains a viable opportunity for profit and resources, there is currently no operating legal framework to regulate such operations. While the Artemis Accord sets rules for lunar exploration, the lack of a similar alternative for asteroid-based mining operations leaves humanity with no present mechanism to prevent any conflicts, such as environmental issues, which may arise through the practice. Conclusion. The frameworks of space law currently stand at a crossroads where the nuances of international cooperation, commercial interests, and technological advancements attempt to converge. As the international community navigates the expansive horizons of the constantly evolving arena of space exploration beyond Earth, the development and implementation of legal frameworks designed to ensure the responsible and peaceful use of space resources has never been more important than in the present day. Since its Cold War origins, the development of space law reflects the constant desire and changing dynamics that underscore mankind's endeavors into the unknowns of space. In order to keep pace with the avalanche of continued developments in space law, both governmental and non-governmental entities must continue to call for dialogue, cooperation, and adaptation to conquer the challenges and opportunities driving humanity's quest to conquer the final frontier, the unknowns of outer space. Thanks for watching this presentation. We hope you enjoyed it.